on the record.
Okay. Call to order the meeting of the monthly complaint committee as part of the Sunshine Ordinance Task Force. I'm Rodman Martin, the chair of this committee. To my right is member Matthew Cate. As part of the meeting today, just a reminder to kind of silence your cell phones, be courteous to the people that are around you, and we try to do this expeditiously. This is not a final determination today. Your complaint or the complaint will likely be referred to the full Sunshine Ordinance Task Force. That meeting takes place typically the first Wednesday of the month, and it does not mean you would be here at the next Wednesday, but at a meeting of the full task force. Anyway, I think we begin with.
One moment.
Sure.
Yes, call to order. The time is 5:53. This is the meeting of October 15th, 2019 of the Complaint Committee. Call to order. Roll call. Chair Martin.
Here.
Martin present. Member Wolf. Wolf absent. Member Cate.
Present.
Cate present. We have a quorum. There are no agenda changes that I know of at this time.
Next item.
Give me a moment. My apologies for not putting roll call out to the teleconferencer, but the only thing we have done is call the meeting to order. Next on the agenda is item number 2, public comment. Members of the public may address the committee on matters that are within the committee's jurisdiction, but not on today's agenda.
Is there any public comment?
Hello?
Yes.
You have 3 minutes for public comment. You may begin when you're ready.
So this is Anonymous from 19044 and 19047. I want to thank you for your order or your findings in 19047, and I look forward to the order of determination. I also wanted to thank Mr. Heckel for now providing records without printing and scanning. We are making progress, so that's great. I think the city is doing itself somewhat of a disservice when it over-argues for exemptions in, for example, 19044, because it makes the task force naturally skeptical of the genuine risks that really do exist. And I think the city is not explaining those risks to non-experts well either. So I will actually be arguing for exemptions and withholdings, hopefully at your next meeting, and I can probably do a better job of explaining them well. Now, regardless of the innuendo or assumptions that the city is making against me, I just want to state for the record, I am not a criminal hacker. I do not break into people's computer networks. I do, however, proceed anonymously, though I have assumed that the city has identified me internally long ago. It's not some big secret. We do have a right to request and receive records, and opening a public record file provided by the city is not some sort of hacking. There are 2 important reasons I remain officially anonymous, regardless of what the city has identified internally. One is if you Google me, you can just find petitions to judges where I have won and lost public records issues in the past. And because my resume would show certain Silicon Valley leadership roles, jurisdictions sometimes just trust me more or give me more records or faster. That is not fair. What is public for one is public for all in almost all cases. And the risk assessment that you and the city should be doing is always what is the worst thing the worst person can do with the worst intentions. And hopefully I can explain these security risks better to the task force later. I'd also urge the task force in all these cases to ask the city what portion is exemption versus burden, and clarifying and distinguishing those may improve the communication. Thank you.
Thank you very much. Is there anyone else for public comment?
General public comment?
Yes. 3 minutes.
Okay, it doesn't bend. Hi, Michael Petrellis here. I see you boys are new to the, hi Victor. I see you, members of the committee, you boys are new to all this. So here's my basic rap about improving this very important task force. I've been advocating for years to have the monthly meetings aired on TV. I think the cost is about $45,000 to air monthly meetings, the cost for SF Gov TV. It is more than worth that money to spend it. And the Board of Soups just haven't seen fit to do that. But if you guys get a hankering to start pushing for it, let me know. I'll certainly advocate for it at the Board of Soups. And the other thing is, I just want to say thank you for volunteering to help democracy. It's really important that we have this task force, and I've been coming here for years and years, ever since they started. And I think all of you folks really deserve applause because you're volunteering for a lot of long meetings and document meeting. But I know you also are two lawyers, so you're used to that. That's what I have to say. Thanks.
Thank you very much. Is there any other public comment?
This is general public comment, not on the complaint yet.
No other public comment? Okay, public comment's closed. Next item.
Next on the agenda, item 3, approval of the September 17th, 2019 Complaint Committee meeting minutes.
Thing.
Look good to me. I'd make a motion to approve minutes.
I'll second that motion. Any public comment on the motion? Seeing none?
On the motion to approve the minutes, Member Kate? Aye. Kate, aye. Member Wolf? Wolf absent. Chair Martin?
Aye.
Martin, aye. The motion passes. Next on the agenda is item number 4, file number 1984, complaint filed by Mo Green against the City Attorney's Office for allegedly violating Administrative Code, Section 67.21 and 67.25 by failing to respond to requests for documents in a timely and/or complete manner.
Okay, is a complainant here? Mr. Mo Green, hi, how are you? Yes, sir. You'll have 5 minutes. Okay?
Okay, well, my name is Mo Green, and the reason for me to file this complaint is because I've been requesting for documents and sufficient responses from the city attorney and also through the PUC. In terms of the requests I was asking for, I submitted a list of requests through the Sunshine Ordinance as a last resort regarding discovery requests. One of it is dealing with interrogatories, requests for omission of documents, and also for documents, production of documents. I started initially issued that to the defendant or the city attorney, which was supposed to go through the actual San Francisco Public Utilities Commission. Initially was July 3rd, 2017. I also submitted a request in December 18, 2017, and also January 13, 2018, and the last was December 4, 2018. So during this time, the responses from the city attorney and the PUC was objecting to my demands. They denied a lot of my claims in terms of producing documents, and to the point we had to request the judge. I had to submit a letter brief to the judge in order for them to provide documents that they were saying was burdensome or vague, or they refused to provide. So the judge issued a meet and confer process for me and the attorney to provide documents. Subsequently, they have provided some documents, and they're going to probably allude to they provided 8,000 documents, but the documents that I asked for wasn't pertaining to some of it wasn't pertaining to the actual request itself. So what I'm just trying to do is basically get the documents that was requested, if possible. This was a last resort. I never went through the Sunshine Ordinance. I understand that y'all help with the providing of documentation or try to push forward that opportunity, and I feel that currently I tried my best in terms of going through the process before I came to this conclusion, and it's been really difficult in terms to get the documents. And so this is where I'm here. In terms of documents that I did receive, some of it was redacted. Some of the redacted information was even pertaining to my information, which I'm I'm privy to that information. I need to know that information because, for example, I applied for a job. I wanted to know in terms of why I was accepted or rejected. Other redacted information that will be helpful to my cause and my case. So I provided a list in terms of requests through the Sunshine Ordinance. I don't know if you have it, but I don't want to go through all in particular, but it was probably like 5 pages regarding the list of requests I asked for. So I guess in terms of short, I'm just looking for documents and sufficient responses from the city attorney and also through the PUC, Public Utilities Commission.
Okay, thank you very much. Are there any witnesses or other parties in support of the complainant wish to speak? Seeing none, is respondent here? All right, please step forward. Please state your name, and we'll give you 5 minutes as well.
Certainly. Good evening, task force members. John Cote. I am the communications director for the city attorney's office. So first, I trust you have already read our written response in this matter. It's dated September 17th, and I believe you'll find it on page 297 of your packet. I'll be very brief. First, there's a threshold issue here. There was no public records request issued to our office from this complainant, Mr. Green. While there is a voluminous amount of documents in your packet, nowhere in the record before you is a public records request in this matter. So absent such a request, this item is improperly before you, and I ask that you dismiss it today. Now, secondly, as Mr. Green referenced, he is currently in litigation against the Public Utilities Commission in federal court. So our office is representing the PUC in that matter. So as part of the court case, Mr. Green has submitted various document requests and other interrogatories to the PUC. So these are not public records requests under the Sunshine Ordinance or the California Public Records Act. They are part of the legal process known as discovery. It is part of litigation and it is overseen by the court. So the federal court has jurisdiction over the discovery process, not the Sunshine Ordinance Task Force. Now, as an aside, the PUC has responded in a timely fashion to those discovery requests, including producing nearly 9,000 pages of documents on 13 different occasions over the course of 2 years. The city has complied with every court order regarding discovery. Now, because you have no public records request before you in this matter, and because the complaint deals entirely with matters before a federal court that the Sunshine Ordinance Task Force does not have jurisdiction over, I ask that you resolve this matter today and dismiss this complaint. There's no need to send this to the full task force, and I'm happy to answer any questions you may have.
Okay, thank you.
Sure.
Is there any other party or person in support of the respondent? Seeing none?
For Mr. Green, if I may.
Mr. Green, can you
Come up with just a couple
come
of
back up?
questions.
Thank you.
And really, I mean, as you understand, I guess the question really is, that I have is, did you make a separate request outside of litigation? We're hearing that the only requests are really in the litigation context, so you or your attorneys, in the context of the lawsuit, asked for information. Have you submitted any other requests outside of the lawsuit?
I don't remember going through like the Sunshine, like a little certain email system, but my understanding was as long as I make a request to a public agency, that should be sufficient because it is a request. I didn't know I had to go to some type of portal in order to make a request. I wasn't familiar with that particular portal. So when I was going through the litigation, I made a request through the city attorney regarding certain documents. I wasn't unaware of this certain email system of Sunshine. I didn't know that until I did my research and came here. And so this is why I'm here. But I did make a request to the city attorney, and also in conjunction, they go to the PUC, Public Utilities Commission, in order to get that information. And they've been basically stalling. So that's the situation.
And just to clarify, I'm not necessarily asking about, or in terms of, I guess, going forward and future requests that you may have to the city. You don't necessarily have to go through a certain portal or do anything like that. Just, I guess, the issue that I'm sort of having, and I think that's the question that I have, if you want to continue after this, I guess, Member Martin, is that, in the context of litigation, I mean, it's hard for the task force, I think, to come in and to dive into a litigation discovery dispute where the lawyers are talking about objections to requests for information in the context of litigation, which is a different beast. Conceptually, it's different, and legally, it's different than making a records request outside of litigation, or at least in terms of what we can do as a task force. But there may be people, and this is another thing, maybe Member Martin, there may be other people on the task force that disagree with me, but I mean, I'm inclined to think that we don't have the jurisdiction here, just because this is a request. The records that are requested, the documents that are requested, would be, generally speaking, very broadly speaking, public records based on some of the RFP languages that I've seen. The request for explanations, so the interrogatories and the request for admissions, those wouldn't really be records requests under the Sunshine Ordinance.
Okay.
I'll leave it at that. They can get a lot more complicated because there could be an obligation for the city to help you find information that you're looking for. But again, when you're asking for descriptions or you're asking for the city to create a bunch of information in response to a question, that's typically not going to be something that the Sunshine Ordinance is going to require the city to provide. Documents is a separate thing. But again, the problem that I'm personally having is the context in which the request was made, and whether it's fair to construe the request for documents that you made as an open records request under the Sunshine Ordinance and the California Records Act, as opposed to questions that you can ask in the course of litigation. And that's just kind of the problem that I have. And with that, I'll kind of leave it to Member Martin to continue.
Yeah, Mr. Green, I think it seems a little technical, that's because it is. There's no portal or anything like that. I guess there may be.
Yeah.
But you could email and make a Sunshine Ordinance document disclosure request and do it that way.
But to who? Sorry.
That's
But
okay.
to who?
There's if you made it, as I understand it, if you put that in the subject line and you send it, they're obligated to forward it on to whoever's doing the records search. I mean, they have to start helping you at that point once you make it clear.
I'm just saying they not have that. This is the reason why I'm here, because they mentioned they gave me over 9,000 documents. That's the problem.
Yeah.
During that time period, the 9,000 I've been asking for this since 2017. So I made a request for information. Now you remember. So regarding documents, for example, I asked for the racial breakdown of the Public Utilities Commission. I just recently received some of the documents. So for them,
Did you do that through the civil litigation process in federal court, or did you do that through the Sunshine Ordinance?
See, I was like, what Sunshine? The thing is, that's why I was referring to portal. Is I don't even know what portal to contact.
I think the way to think of it is you have your civil litigation federal court going on.
Correct.
Right? And outside of that, you could just, as an ordinary citizen, make the request to the custodian of records or the city attorney's office through saying, I would like these records via as the Sunshine Ordinance Task Force allows me to, or Sunshine Ordinance allows me to try to obtain them. So it's technical, but it's two different kind of ways to get the information, and we are only kind of here to oversee the one way.
Okay.
And I know it seems annoying and duplicative,
Well,
because it kind of is. But in order for us to have jurisdiction to hear something, right? Something has to have been typically requested, through a public records request, not through civil discovery. And there might be members, like Member Kate said, who they say, well, they had constructive notice. I could see this happening, and therefore they should have referred it to the custodian of records or whatever, okay? But they are challenging whether this task force at this time, today, doesn't mean if you did this tomorrow that we wouldn't have okay, you know what I mean?
Okay.
So, as of today, has jurisdiction over this issue. And they have a colorable argument that we don't.
Well,
I'm just saying, other people might disagree.
well, I just think it's public records. So I could see maybe certain records they won't provide, but it's public records. So for me to go through a portal or to go through them for the same information I'm requesting, and they've been deliberately withholding information, I mean, for like over 2 years. And so this is the reason why I'm
right.
here. I
Well, I
wouldn't even
think
be here for this reason.
Correct. And no one's saying, I don't think that, you're here today, you're getting there, but it can be a little difficult to navigate, especially when you put out interrogatories and you don't feel like you're getting proper responses, and then you go, oh, well, the Sunshine Ordinance says they should give this stuff to me. I think that's kind of how we ended up here, but there was no complaint, public records request made pursuant to the Sunshine Ordinance, okay? And Ms. Member Kay can...
And another, I guess, thing to keep in mind is that potentially, I mean, there could conceivably be different standards that maybe require the city to be over-inclusive in its productions if you make a records request as opposed to a case where you've got a lawsuit and you're asking for documents. There's just possibly different standards that the city's response is going to be looked at through, different lenses that either the task force or a court, whether is going to look at it maybe differently based on the burdens of a lawsuit, the burdens of a records request. I guess one thing would be, I mean, can you help us and kind of help us talk with you a little bit about what are some of the records that you've asked for that you haven't received in the big number of documents that you've received? What do you feel is being unfairly or rather improperly both withheld?
Okay, well, I would racial breakdown of the Public Utilities Commission in terms of African American and Native Americans in management and supervisory positions. I haven't received that, and I applied for several jobs within the city, and I requested the people who received those particular jobs, who held it before me, and because I wanted to know why I wasn't considered. I've been working for the city for over 10 years, have three degrees, 2 in engineering and 1 in urban planning, and I haven't received any promotion through that. So my complaint was discrimination based off of me not receiving promotions, to not receiving professional training, going to conferences that would help me to be more, have more skills under my belt, to operate the whole, let's say my whole profession. I haven't been receiving that. And so I was asking for stuff that's pertaining to my claims. And to me, it's valid because if I apply for a job, I would like to know who received the job and also who held it before previously. And I wanted to know the breakdown of the people, African Americans, because in terms of the county of San Francisco, there's a big issue with African Americans being hired and Native Americans being hired in managerial and supervisory positions. I mean, I know we have the mayor who's African American, and some other people in positions, but that doesn't mean that discrimination doesn't take place. This acts, former President Barack Obama. So discrimination is rampant, and racism is rampant. So I'm trying to get documents pertaining to stuff that I feel that it's public record, and I'm entitled to it. And so I tried different steps. I wouldn't even come to this conclusion if I didn't go through the city. I went through the city. I don't know the particular portal, or who the designated person for the Sunshine Ordinance in the public utility. They don't make it available. And also in terms of my experience dealing with the city, They're not trying to provide documents to me based in point into my initial complaints, my requests. They objected, they denied. I mean, the terminology they used was, it was just like, okay, lack foundation, vague, not relevant, unduly burdensome. This is what I was getting through all my discovery requests, to the point that I had to submit a letter to the judge requesting them to provide documents that are sufficient responses that the city refused to do so. So they've been trickling down and giving me information here and there. So they say 9,000 documents over this time period is a reason for that time period, because they wasn't given to me from the initial point. I provided my responses in a sufficient manner, and I provided everything. I replied to every request that the city has made for me, but they have not. And the ones that documents they have provided is very limited, to the point where they changed the narrative, they redacted information that's pertaining to documents that I already received. For example, a spreadsheet I received, they blocked out, redacted a whole bunch of information in terms of if I accepted or rejected position. Now, I applied for the particular position, in the product manager position, and they redacted that stuff, even my information. So I don't even know if I was accepted or rejected. I know I didn't get an interview, but in terms of the scorings part,
Okay. So
I don't
there's
know.
a substantive part, right?
Okay.
To what's going on, but right now it's just, are we properly here? As annoying as that is, and are the documents public? I mean, I think
they
it's-
are, I believe.
Well, right. I mean, I don't know if they would even contest that at if there wasn't the jurisdictional hurdle at the beginning, but you know, for purposes of today, Mr. Green, it really is, are we rightly here today?
Well, what's the purpose of the sunshine ordinance? Is to help the person who makes a complaint to get
It is.
access to public records.
Right.
So,
So that's why I'm comfortable referring it to the full task force. Member
Okay.
Kate, would you?
yeah, because I'm new to this. I don't know.
What do you think?
If you want me to make a request to the portal I can do that to make it easy for y'all. I can do that when I get home. But I already
something
made a
to add?
request.
Oh.
To-
I mean, I guess Mr. Green, I really, I very much dislike discovery and some of the responses that you've read about objections, and that's unfortunately a lot of part of what lawyers do for a living, and it's really frustrating whenever whenever you have to do it and whenever you get it in response. A concern that I have, and I hate to be so proceduralist, and you want information from the city, and you don't feel like you've been adequately given that information, or you've not had an adequate response to that. And just the problem I have is that it's in the context, exclusive context of the lawsuit. And I hate to be overly, it's different standards, I think, that can apply in a lawsuit context, to where in a lawsuit there may be records that you would be entitled to get that the public wouldn't get, and then vice versa. Sometimes public records requests, you might be able to get it that you couldn't get in a lawsuit. And so it's a trickier situation to have, different rules that are court rules that determine. It's just harder. It's a lot harder. And it may be that the better course, although it is a little bit more of a burden on your end, would be to think about the records that you want, that you did not feel like you received, and then to just, if it's the Public Utilities Commission or if there are other agencies involved, send an email and ask them of those specific documents that you still feel like you aren't being, that they've withheld, or you feel like they've withheld, is to maybe go through that process. And I know it's an extra step. I just would feel like that would better, present the issue for the task force. And I dislike having to recommend that.
Yeah, but I'd recommend that as well. I mean, that is going to be your easiest
it's believe me, if I wouldn't be here if it was. I mean, it's basically, I appreciate your response, but I'm running into a wall here.
Right, but
because
there's
it-
nothing we can do today that will make that wall less onerous.
And
There's
Well-
nothing we can do here today that makes that less onerous.
Did you say you can push it towards the Board of Supervisors?
No.
No?
no, the next step from
What's
here
the next?
is kind of, and again, this is where there's more process involved, which can be good and helpful. But the situation here today would be to whether the question in front of us today is whether the task force has a basis that it can decide whether the city has acted, improperly or has unfairly withheld documents. We don't make that decision today. What we do is we decide whether the other, 8 or 9 people who are on this task force have enough information or have a legal basis to examine your complaint. And so what would happen, in a sense from your perspective, the best case scenario is we would vote to then send it to the full task force, and then sometime, and then, probably on the other side of New Year's, we would be back in front of the task force, the city, the Public Utilities Commission, and you, talking about sort of these same issues. And then there'd be a vote. And then potentially you would be told, maybe not, but maybe you would be told the same thing, which would be, we don't have the ability to vote on this, so maybe if you want these records, maybe you should ask the city in a public records request under the Sunshine Ordinance. And that may only delay, it may be just as fast to try it that way. And I appreciate your frustration.
It'd be
but-
faster.
Well,
So they have to respond within, what?
Yeah, I mean, it could be faster, but it's hard to
Well,
make that promise.
Well, I can try that. I believe I made a request. I just don't know exactly when, but it wasn't through this certain custodian. I don't know who the custodian is, but I think I know now because they responded to my complaint against the PUC, and so now I have the information on the person. But the thing is, even if I make that request, I'm going to still be in a situation where they're not going to provide me the information.
Well, we don't know. I mean, we really don't know. I mean, if you put in the subject line, we don't know.
Okay.
If you put in the subject line, public records request, and then say according to or under the Sunshine Ordinance,
Okay.
and then but when you are explaining what you want, you have to be clear about what you want to obtain and stuff like that, because it makes their job easier.
I have it
And if
already.
they aren't able to provide it, they'll be able to tell you why, and then if you have an issue with that, you can come back here.
So can we postpone this? I mean, how does that work? I'm new to this.
That's okay.
Sorry.
If you file as a public records request and there's an issue with that, that would be a new complaint. It would not be based on these items that are before us today.
It would be, ultimately, there'd be no difference in the timing if we closed this complaint out and then you asked for the records request like we're talking about. Whether we continue that, you could definitely come back. You could file a complaint with the Sunshine Task Force, and so that essentially kind of starts it over again, but the timing wouldn't be any different than if we continued what we're doing today. That doesn't make much of a difference, except that I think internally for our own files, we would close this one and then wait to see, if and when, most likely, probably when you file a complaint, then that'll start this procedure back and you'll come back here and we'll go from there.
I was just thinking about, can we just have it as pending? Because I will file it. If you want me to go through this portal of a custodian, I would do that. But the thing is, who's a custodian for the city attorney? I mean, they have a generic, I think it's a generic, but who's the custodian? I mean, I figured Mr. Lake, and we said John Conte, I forgot, maybe I pronounced his last name wrong. My apologies, but who's
We can
the
get that
custodian?
information to you. That's not a problem. We can
That's
give you the
okay.
custodian of records
Yeah.
for both departments.
Okay, I appreciate it, Victor.
And then you can send the request directly to the custodian, and you would need to provide a detailed list of documents that you wish to receive.
I have that already.
Right.
And you just make a request request for public records pursuant to the Sunshine Ordinance.
Okay, request, okay.
And would you like to, we can, The options are that you can withdraw these complaints. The committee can find that they have no jurisdiction and forward to the task force with that recommendation, or we can continue these and see what happens.
So if we were to,
Sorry,
It's okay.
I thought I had it off.
What?
that was a cell phone.
That wasn't a
Sorry.
raptor, it was a,
Excuse me. I mean, well, so if we were to find no jurisdiction, would we still then refer it to the task force?
Yes, only the task force can make a final decision,
okay.
and it may be best just to leave it in committee and see what happens with the public records request.
That's fine with
Okay.
me.
Then in that case, we would leave it open and then.
We will continue this matter to the call of the chair pending submission of an additional public records request by the complainant. And if that satisfies you, you can always withdraw your complaints.
Okay, that sounds fair. I will submit it, and so I just need to know the exact person, because I don't want it to be in the, no virtual, I don't know, internet, like, it's just surfing somewhere. I don't know if it's not gonna even be read, but, so I just need to
Okay.
know the exact
Okay.
person from the public utilities.
Am I assuming this is for both files, or is it just for the one against the city attorney?
Well, see, for me, I went through the city attorney, and they challenged it to the PUC, Public Utilities Commission, because they're the employees that I used to work for, and so at the end,
Maybe we can ask the respondent, are these separate or are they similar? Or are they connected?
I believe it's the same.
Hi, yes, I'm Joseph with the city attorney's office. I guess the Sunshine Task Force.
You step up
Oh,
to the, that's
to the-
okay.
Yeah, Joseph Lake with the city attorney's office. The task force separated them into two separate complaints, but our office has been representing the PUC. And as you know, both complaints are related to the discovery process. So administratively, I don't know why they're two separate complaints since it's the same issues, but that's
I'd
all
like
we
to
know.
read the next item, and then we can,
We can kind of
Just-
just, if you read it, then we can kind of deal with them at the same time.
yes.
Mr. Green, is that okay? So we'll just read the next item because they're pretty much overlapping, if you agree. Okay, thank you very much.
I agree.
Okay, thank you.
File number 19085, complaint filed by Mo Green against the Public Utilities Commission for allegedly violating Administrative Code Section 67.21 and 67.25 by failing to respond to a request for records in a timely or complete manner.
Thank you.
I don't know if you want to hear from the PUC at all, since they're the named party.
I was gonna say, Mr. Green, is it pretty much the same issues you had with the city attorneys as with the PUC?
Pretty much. They haven't been giving me the information regarding the stuff, the breakdown of race, and well, I have it now just because Mr. Lake provided it, but it's
Okay.
not broken down into managerial and supervisor. Like they provided the list of positions, but like which one is a
Right.
manager?
But is it the same preliminary issue as far as you can tell where they're saying, you didn't go through?
Well,
and
I
ask
don't know.
for-
I mean, I'm assuming
Okay.
based on what they told me, but if PUC is there, I don't know if there's a representative here.
Well,
for
they're here.
PUC. They
I
can
just wanted to
speak.
see if you wanted to do
Do
your
'em jointly?
essentially 5 minutes later, if you want to do it, okay, jointly.
Yeah, I'm okay with doing it
Okay,
jointly.
thank you.
We can hear from the PUC.
Yeah, if the PUC
and that
has, maybe can explain kind of.
Because it also may be helpful to the extent, I understand litigation's one thing, but if there are some records maybe that you know that might exist, or if they don't exist, it may be helpful for Mr. Green in terms of formulating a
Of course.
follow-up.
Good afternoon, gentlemen. Thank
5
you for
minutes.
having me. My name is Cassini Angusteria with the PUC. I'm the Deputy Director of Communications. Public Records is within this department. I'm here to, and what you're going to hear is going to be pretty consistent with what you've heard all along, which is that SAPUC is represented by the City Attorney's Office in the litigation that was just previously mentioned, the litigation that's subject of Mr. Green's Sunshine Ordinance complaint, and we concur with City Attorney's Office in their response. In addition, I'd just like to state that we have no knowledge or evidence of verbal or written requests from Mr. Green via public records, and we documented this in a letter. back to, letter to you all, the Sunshine Ordinance Task Force, on September 18th. We have a copy if you'd like, or
I think we've got it in the packet.
that's all. Thank you.
And just a quick question. In terms of the email address for public, is it publicrecords@sfwater.org?
Yes.
Mr. Green, okay.
I
Thank
will
you.
provide everything to him via email
Okay.
and confirming with all the parties.
Anything else? Do you want to make a motion?
Oh, we can let her,
Oh, do you have anything else to?
No.
Okay,
thank you.
thank you.
Thank you.
I believe we can continue this matter to the call of the chair,
Yeah,
and we can review the matter once the public records request is made to both departments.
Okay, I would make a motion to continue both of these items to the call of the chair.
I'll second.
Is there any public comment on that motion to continue the matter at the call of the chair?
Yes.
Please, you have 3 minutes.
So I just, anonymous here again, I have no affiliation in any way with this case or the complainant or anything, and this is directed to the task force and is not in any way legal advice for the complainant here. I would just like to remind the task force that I don't believe under 67.21B there's anything that would exclude a request made under civil discovery. Now, maybe there are other laws that preempt the Sunshine Ordinance, but it just says receipt of a request for inspection or copy of a public record and shall comply with such request. So it can be fax, postal delivery, or email, or orally. So I don't know the answer, but it's possible that even a discovery request could be a public records request. So maybe something for you to consider. That's it.
Thank you. Any other public comment? Seeing none?
There being no additional public comment, can we pass this matter without objection?
Yes.
The matter is adopted. The matter will be continued to, the 2 matters will be continued to call of the chair, and I will work with the complainant to get him the email addresses for the custodian of records, and we do expect that a formal public records request will be submitted to both departments.
Thank you, Clerk. Mr. Green, thank you for appearing today. Good luck. Okay.
Thank you, gentlemen, and the person who's on the.
You're very
Appreciate it.
welcome.
Thank you.
Thank you.
And thank you, city attorneys and PUC, for showing up today. Appreciate it.
Next on the agenda is item 6, 19093, complaint filed by Michael Petrellis against Mayor London Reed and the Office of the Mayor for allegedly violating Administrative Code, Section 6721, by failing to respond to a request for public records in a timely and/or complete manner. I believe that Mr. Petrellis is here.
I just think so. Please state your name, and you have 5 minutes.
I'm ready. Hi, Michael Petrellis. This complaint is a continuation of other complaints against the mayor's office regarding basic documents, production of them, and regarding calendars. So I hope you had a chance to look over what Hank Henkel sent from the mayor's office regarding Sean Ellsburn's calendar. Many weeks of calendars were not, that I requested, were not provided to me, and on many days, there is only one event listed on his calendar. I don't believe they have acted in good faith. I think that they are willfully withholding public records, and I would like for the production of these records. Basically it.
Okay, thank you. Is there anyone else in support, witness thereof, of the complainant who'd like to speak? Seeing none. Respondent here? All right, please state your name. You have 5 minutes.
Hi, I'm Hank Heckel. I'm the compliance officer for the Office of the Mayor, here to respond to Mr. Petrellis' complaint. Good evening, Member Kate, Member Martin. I think hopefully we can get some clarification on the issues raised here in Mr. Petrellis' complaint. So just to recap the background, Mr. Petrellis sent an immediate disclosure request on August 16th to our office for Chief of Staff Ellsburn's calendar, pretty much for the duration of his tenure so far from October 2018 up until the date of the request. We informed Mr. Petrellis that we would be taking the full amount of time for a regular records request of 10 days due to the need to consult with other departments rather than responding in the IDR period. We then answered and responded on August 27th and provided the available calendar records of Mr. Ellsburn that were in existence at the time of request, about 40 pages worth of calendar entries spanning a period of time from about February 2019 until August. So just to clarify, Mr. Petrellis' complaint alleges that the Office of the Mayor failed to provide the full and complete calendars of Chief of Staff Ellsburn. On the contrary, the Office of the Mayor performed a search for all calendars relating to city business in the possession, custody, or control of Chief of Staff Ellsburn and staff, and provided Mr. Petrellis with all of the available calendar entries. No calendar days retained in the possession of Chief of Staff Ellsburn or staff were withheld. There can be no violation for not producing documents that do not exist in the custody, control, or possession of the respondents. So just to be clear, I think getting to the crux of the issue here, we gave all the entries that were available at the time of the request. There were no other entries to provide. Chief of Staff Ellsburn keeps his calendar for purposes of his own reference and convenience. It seems that there's a bit of a conflation here with maybe a Prop G calendar issue, and we've explained and set forth in our submission that Chief of Staff Ellsburn is not subject to Prop G. That is not what the relevant provision of the Sunshine Ordinance requires. A staffer, even a high-level staffer such as Chief of Staff, is not covered by the text of the ordinance, which covers the mayor, members of the Board of Supervisors, elected officials, and department heads. This very issue was raised by Mr. Petrellis a couple of years ago with respect to former Chief of Staff to the Mayor, Steve Cava, and pretty much the same issue, I think, was raised regarding whether Mr. Cava was required to keep and maintain calendar entries. He kept them for, I think, a certain period of time and no longer retained them after they were needed. That went up through the task force and up to the Ethics Commission. There's a record that we've referred the task force here to that includes letters from the city attorney's office. The city attorney took the position that, as I've stated, the chief of staff is not subject to the Prop G requirements, and nor is there anything in the Sunshine Ordinance that requires creating or maintaining calendar records for the chief of staff. General record retention laws covered in other parts of the administrative code, section 8.1, that is not altered or abrogated or changed by the Sunshine Ordinance. These sort of personal calendars used for business are kind of akin to notes, day-to-day emails, other types of phone slips, things that just aren't subject to retention, whereas Prop G is a very special law that was established to create an affirmative record, including a historical record, going back a certain amount of time for the public to access the meetings of their officials. And so, again, the confusion here may be that over what exists, we produced what exists, and there's nothing else to provide.
Thank you. Is there anyone else here to speak, a witness thereof, of the respondent? Seeing none?
One thing before we proceed further, I was wondering if this complaint should be against Chief of Staff Ellsburn and not Mayor London Breed. It would still be against the office of the mayor, but
Right,
it would
that-
be,
It's possible.
I mean, are we even allowed to change that? I mean, the
the
complainant.
parties are all present today, and if it's agreeable, we could do it, but I'm not sure what Mr. Petrella's feeling is on this.
Mr. Petrellis?
I have a question. What's the benefit to me as the complainant amending the complaint to be against Sean Ellsburn specifically?
Well, it's just a matter of procedure because this is not regarding Mayor Breed's calendar, and I think it is misleading to have her name listed as the respondent.
I mean, I think that also if he's part of it, he has to respond with his calendar, you know? That might be another reason. But I mean, I can see he is part of the mayor's office, I get that. But it is his calendar.
Understood. Let's move it forward. I have no objection to making it specific to Sean Ellsburn, who happens to be the chief of staff to Mayor London Breed. Fine.
If there's no objection, I will change it from Mayor London Breed and the office of the mayor to Chief of Staff Ellsburn and the office of the mayor.
Okay. Any questions?
Mr. Petrellis, I mean, it sounds like this is, it seems like I was picking up some issues, sorry.
Yes.
There you go.
One way or the
I
other.
used to sit over there, and now, but, so as far as I can tell, there's basically two issues, or one of the issues really, is that whether or not the chief of staff was required to retain calendars from the past. That's what's one of the issues, and that'll have to do with basically whether the ordinance does or doesn't incorporate the chief of staff into the records retention requirements of the Sunshine Ordinance. Is that a fair summation of one issue?
Yes, because I believe this matter was settled years ago with Steve Cowa that he's creating a public record, which is his calendar, regardless of Prop G and any other excuse the mayor's office may want to throw at you. The chief of staff is creating a public record, which is his calendar, and the public should have access to it.
I think this gets to your point you made months ago, which is that if a public official also chooses to make a public document, it doesn't mean Prop G is the only calendar. It could be one of 8 calendars. And it doesn't mean that none of the other ones are public. Yeah, it's pretty much.
I mean, the only thing I mean, I think we've got everything we need, I think, to make the determination that there's jurisdiction, that these are public records. It's an interesting issue in terms of how far it reaches and all the rest. I mean, is there anything else we should know that's not in the information you've already submitted about the complaint that we should try to ferret out in this process? Or I mean, otherwise, I mean,
Yeah, we're just going to refer it to
I'm ready to make the reference, or, you know, the referral to the task force and move on. Just because I agree that this is something that's properly before the task force and that these are public records. I just don't know if there's any other information. I mentioned the one issue. Is there another issue, I guess, is a better way of putting it in short, that you're bringing to the task force?
Yeah, I don't want to be here again about this. And this should not be taking up your time. And when I spoke during public comment and said, thank you for your service to democracy, what I am talking about is this waste of our time that unfortunately is not monthly aired on TV to show the public the mayor's office and others in the city family hindering the access of the public to public records. Yeah, that is the big elephant in the room.
Okay. Point taken.
I can appreciate the frustration on the time that this process takes. wish it were a little bit more streamlined, and that we could bring these issues up for, for the complainant's sake, for the, the city's sake, that we could do this in a little bit more of a streamlined manner, but we got to work within the system that we've got presently, and so I appreciate your frustration. I would, barring any further comment from you or anything else, I would just make a motion to find that the records at issue are public, that the task force has jurisdiction, that we would refer this to the full task force.
And the committee before the committee. I'll second it, yeah. I'm sorry, but this, when we, sometimes for due process purposes, this, I think it is for due process purposes, people want the full task force to hear the issue. And the preliminary meeting today can be annoying and onerous and time-consuming, but it helps sometimes to narrow it down as far as, yeah, we think there's jurisdiction, yeah, these documents are public, now just how does it shake out? So I apologize. I know I appreciate everyone coming here. But anyway, I'll second your motion to refer it to the full task force. Okay. Is there any public comment on the motion? From people who aren't, there's no rebuttals at the complaint committee level, if I remember correctly.
You may submit additional documents before the next meeting, if you have anything additional to provide.
Any public comment from people not a party? Seeing nor hearing any?
There being no public comment, may we approve the motion without objection?
Sure.
That motion is adopted. Next on the agenda, item number 7, file number
Thank you for appearing. Thank you for the time.
19091, complaint filed by Anonymous against Mayor London Breed, Hank Hankel, and Office of the Mayor for allegedly violating Administrative Code, Section 67.21, 67.26, 67.27, and 67.29-7 by failing to respond to requests for public records in a timely and/or complete manner.
All right, is Anonymous available?
Yep, I'm here.
Okay, thank you. You'll have 5 minutes.
You may begin.
All right, so Anonymous here again. This is case 19091. If you had flipped to page 31 of your PDF or page 657 of the record, this is regarding a series of requests made to the mayor's office regarding sampling of recent types of communications of all forms, some business communications conducted on personal accounts, and your usual native format and metadata issue. So if you would go to the next slide, which is the timeline and facts of the case, there were actually 2 series of requests in this issue. It turns out that only one of them was analyzed by your DCA, but you can ask me questions if you would like. On the next slide is an argument that you do have jurisdiction over all individual named respondents. I don't know why it was left off of the agenda, but it was analyzed by your DCA and it's in my complaint. These are persons who are custodians of their personal communications. If you go to the next slide, you can see the series of allegations in case 19091. There are a series of different kinds of allegations. There's allegations regarding the city of San Jose where they've either withheld improperly or haven't searched private property for public records. One of the respondents didn't give records because of a disagreement over the title. There's a clear issue with printing and scanning records. I think you've held that before regarding 6721L. Even if they don't have to give MSG and EML files, they can't print and scan records. The redactions were given without any clear reference justifications. It's just a list of justifications and then hundreds of redactions. They withheld without justification images, URLs, portions of messages, city email addresses. Now, there was also an attachment, and they have implicitly admitted that they withheld this because they just provided it a few days ago. There's also a novel allegation, and this is a new legal theory, I guess, under 6729.7, which is a failure to maintain records in a professional or business-like manner. And you can find evidence of this in the record. Particularly, I don't know I can get the page number if you need me to. There is one of the respondents using a personal WhatsApp account solely for government purposes, as there's a statement from Mr. Heckel, and they aren't actually able to provide some of the records so far from that account because of the way it's stored, I guess, in WhatsApp. I don't know, maybe Mr. Heckel can clarify these issues for you. That request isn't in this complaint, but the fact that they're unable to provide these, which they believe themselves are public records, they're photographs of the mayor, I think, at some business event, that is evidence that of 6729.7. And finally, there's the issue everyone loves, which is that respondents withheld certain email headers, but we can split that off. So the recommended committee action on the last slide here is find jurisdiction over the subject matter and all respondents and find that the requested records are public. I please ask that you say all the named respondents because they're not in the agenda correctly, even though I cited them. Then you can divide the email header allegation number 8 into its own case number. And if you want a precise motion language, it would be dividing determinations number 11 through 14 of the supervisor of records petition dated September 10th in this case into its own case number, refer that case to the technology committee. I think it'll be quite fruitful because the metadata in this case is much more interesting than the metadata in 19044. They're both email headers. 19044, if you remember, is just 2 emails. It's one email I sent to the city attorney and one email they sent me back. So I think the emails in this case will have more interesting things to discuss. And finally, please refer to the remainder of this case, which has no computer science issues, it's just legal issues, refer it to the full task force. And in the last few hours, I do have a proposal. It's not in this presentation. Right now, the supervisor of records has made a ruling that everything I've requested, except for that one attachment, is properly examined and they don't have it provided for me. You need to overturn that even for the most basic reasons like printing and scanning and to investigate the other City of San Jose issues. But I can, if your task force will allow it and the city agrees to it, I think we can have a stipulated compromise order for just the things that are obvious, which are the printing and scanning 6721L, the reference to justifications, and that one attachment. And if they're willing to stipulate to an order of determination and you're able to do that, then when they have to reproduce these records correctly, I can just say, let's ignore 90% of the records, get say 10% or maybe even just 10 exact emails that are most interesting, and I would waive the disclosure of the rest of the records. So that's my offer if you're allowed to take it. Thank you.
Thank you. Is there any witness or persons in support of the complainant? Seeing none, respondent? Is respondent here? Mr. Heckel is here. Please state your name and get 5 minutes.
Hello again, Hank Heckel from the Office of the Mayor. There's sort of a lot of different pieces, I guess, in this complaint. Just to start, I would say, as Anonymous pointed out, there are a number of quote unquote metadata issues which we've sort of been through extensively at the last full task force, and the task force has scheduled a special hearing on that at October 22nd. So I would agree with Anonymous that any metadata issues concerning email headers and the like should be essentially diverted to that hearing. I think it's premature to reach a conclusion on any of that. As to some of the other issues that Anonymous raised in his complaint, this is one of, as he's mentioned, quite a large volume of requests that he's issued to the Office of the Mayor as well as other departments. This one was entitled, I guess, a purported electronic communications audit. It encompasses, as he said, a sort of random sampling of communications from at least 8 officials in the mayor's office across at least 17 different electronic media. We conducted a thorough search to cover those various types of media, to cover those types of communications. We took an extension due to the need to consult with other city departments and due to the volume of responsive records. We first responded on July 29th. We responded again on, we first responded on July 26th. We provided an amended response on July 29th. And I just, like to point out, I mean, we've tried to make it very clear to Anonymous that we've searched across all the media that he has asked us to, including personal email accounts pursuant to the San Jose case. We informed him of this in our response, as you'll see in the record on page 821. We informed him we've completed our search and consultation and are attaching here with responsive records located in the possession of the Office of the Mayor. The documents have been provided in multiple emails due to file size. Please note that responsive emails from official city email accounts have been provided for all of the requested custodians. Additionally, responsive text messages from personal devices pertaining to city business have been provided for Communications Director Jeff Cretin, Liaison to the Board of Supervisors Sophia Kittler, and Compliance Officer Hank Heckel. No such responsive texts were located for the other requested custodians. Existing messages received using Signal pertaining to city business have been provided for Chief of Staff Sean Ellsbernd. Signal was one of the 17 different platforms that Anonymous requested information from. These communications are provided herewith as a supplemental production. No responsive communications in the other electronic media named were located for the requested custodians. So I think Anonymous, if you look at his briefing materials, he refers to the San Jose case and seems to be implying that officials are required to provide affidavits that they've searched their personal devices, which is nowhere in the Sunshine Ordinance. If you read the City of San Jose case, as I'm sure Anonymous has, any affidavits in the context of a search for communications and personal devices is only something a court could order. It's only something that would come up in the context of a litigation should these issues go that far. We have done the search. We've searched across personal devices. There's no requirement that we provide some written declaration or sworn statement from the individual custodians. We've made the representation to Anonymous, and we've done the search. Some of the other issues are really just housekeeping. I mean, I think, we're trying to work together in good faith with Anonymous. There's quite a large volume, quite a large burden to these requests. I've personally spent about probably a third of my work time over the past couple months responding to these. Some things are misunderstandings, like he pointed out that we omitted records from Tyrone Jew. His title is Senior Advisor on the Environment. Anonymous's complaint, as we read it, just said Senior Advisor, which is Marjan Philhauer has that title in the mayor's office. We didn't extend that to every person that was a senior advisor for a particular subject area. But we've gone back and looked for records from that individual as well. And we can address some of the other kind of minor issues like the WhatsApp communications that he referenced.
Mr. Heckel, thank you very much. Is there anyone in support of or witness of the respondent like to speak? Seeing none?
Yeah, I mean, I think my questions are relating to kind of at the last end, Anonymous, of your remarks. The proposal you raised of maybe like a compromise, would that pertain to, I mean, everything except the issues of the metadata that we would kind of carve out? Or is this, the proposal you mentioned, is that something that's new? Have you talked about it with Mr. Heckel or anybody at the Office of the Mayor before? What's the likelihood that basically we need to, after carving out the metadata, that we need to have you guys or ask you guys to continue talking about that proposal if that's something that the city would consider?
No, it wouldn't eliminate all but the metadata issues. Basically, I just came up with this idea like an hour ago after this presentation was done, because there's no need for the city to constantly redo this work until the Sunshine Ordinance Task Force agrees that they did it in the right way. It's totally fine with me to do it on a small portion of the records and have those records produced in the way that I believe the law requires them to be done. It's just a waste of time otherwise. So I can tell you the exact proposal if you would like me to do so. Let me know if you would like me to do that. It does not, I just want to be clear, it does, you asked a question, so I want to make sure I answer that. It does not remove everything but the metadata issues. And the reason for that is number 3 and number 6, the proposal, I don't think that they would agree to a compromise regarding number 3 and number 6 and 7. I think they might agree, and I'm happy to agree to a stipulated order of determination regarding, let me see here, number 4, but just for non-printed and scanned documents. I know that they will not agree to a stipulation to MSG and EMLs, because we're going to discuss that later. A stipulation on number 5, and then a stipulation regarding the attachments that they later produced, which were withheld, I guess, by error. The supervisor of records currently has said that they are okay, that the city is allowed to withhold images, URLs, the email addresses. That is not metadata by any normal person's definition. I don't know if the city, if Mr. Heckel agrees that that is metadata. To me, images in an email are not metadata. So it's a portion of the case can be resolved. And my side of it is basically I would waive production of all these hundreds of emails and just say, like, okay, I need 10 of those emails produced in the way I think the law requires the city to produce them.
Would that, I mean, I guess would that affect your complaint in terms of whether you would be withdrawing aspects of it or whether you would be, you know what I mean, as opposed, in compromising,
Yeah.
you would be carving, and I'm sorry, forgive me, whenever you're referring to the numbers, I'm struggling to keep up and find those in the record. If you could help me look
I
at those.
apologize.
No, that's okay, that's my fault.
Okay, let me state that again with some clarity. So we're on page 659 of the record. This is page 33 of the PDF, where I've categorized the allegations at the top. I do not believe the mayor and, Mr. Heckel, as the representative of the mayor's office, and I will agree on numbers 1 and 3, and we won't agree with the MSG and EML part on 4, but that part would go to the technology committee. I don't think we agree on images and city email addresses and URLs in number 6. I don't think we agree on number 7. And 8 would also go to the technology committee. So what you would still have, if they're willing to do the stipulated order, and I would waive then production of the vast majority of these documents, is that the full task force in this case, unrelated to metadata, would have to resolve number 3, and whether images and URLs and other parts of an email, that are not metadata but in the body. And number 7 regarding the inability to produce records from these personal accounts in number 7. So does that make sense?
Sorry, it's a lot of moving parts, and I'm not, I guess
I'd
I'm
like-
not sure. Go ahead.
I'd like to, Anonymous, just to be clear, I mean, I think you talked about bifurcating the issues of the metadata and the email headers, and that
Yep.
being sent to the information technology, I think, subcommittee. That's still the case, correct? That portion would go to the information technology committee for further development and explanation.
Yes, I don't think there's going to be a compromise there. I think we are just going to discuss it on October 22nd. I think that makes sense.
Okay. And the allegations listed in, like you said, on page 559 in the first slide at the top, that's what you're referencing. And,
659, yes.
sorry, 659. 659.
Yeah, it's got a weird.
Yeah. And you're proposing that they agree to that they're in violation of certain allegations? Is that what you're proposing?
Let me be clear about why I can't just withdraw those. The supervisor of records has currently made a ruling on the record that what they did was fine, and I can't just withdraw it. I would need you, them, and you. We would all agree that we could have a stipulated order of determination, because you can override the supervisor of records on a few of these things, which I think they already agree with, that are, like I said, housekeeping or whatever you want to call it, and then the rest would go to the full task force. I right before this meeting, I wrote this up. I haven't been able to send it to anybody because it was, right before the meeting. But I think it's just a lot less work for the city. The interesting parts of the law regarding City of San Jose get to go to the task force, and regarding images and stuff. And the interesting parts on the technology side get to go to the technology committee. And, the parts where we all agree that this is, everybody agrees this is not the right way to do things. I just don't need them to do another 100 hours or whatever, 40 hours of work it might be to reproduce all those records. Does that make sense?
Yes.
In a broad sense, I wonder, so I don't think there's, in terms of what we're doing here at the committee level, I don't think there's any, at least from my perspective, any issues with finding, generally speaking, jurisdiction, and generally speaking that, some aspect of these records are public, and kind of moving the process along. And it would probably be most beneficial because looking broadly at the complaint, it's appropriate, I think, again, carving out the metadata issues to move forward with the full task force on the non-metadata issues. And then the question would be, dive into the procedural weeds, but whether the complaint and I guess kind of to some degree your presentation of it at the full task force could kind of just, to the extent you're comfortable doing so, winnow those issues down to whichever ones. And maybe that's what you're proposing, if the mayor's office were to agree to find that they violated the Sunshine Ordinance?
Yeah, I think, Anonymous, I think what you said, you just put this together maybe an hour ago, or that portion of it. I mean, nothing's going to prevent you from circulating that and discussing that with respondent in advance of the, whenever this is heard in front of the task force, and maybe there's developments in the meantime or something. Does that make sense?
The reason I'm stating it to you and not just the office of the mayor is because your procedures and the statute regarding how you find orders of determination are slightly different. The statute says you have to have a hearing only if the complainant asks for a hearing. It doesn't even say you need a hearing to make an order otherwise. So what I would be proposing, but only if the task force and the city, of course, agree, is that the parts that I believe Mr. Heckel agree are mistakes, and we don't need to just reproduce all the records for that reason. That part, somehow your task force has to issue that stipulated order. Do you have the procedures to do that? I don't know. Do you have the ability or the authority? Maybe that the DCA needs to answer that. I just don't know the answer to these questions. So.
Well, maybe one quick way, I guess we should maybe get Mr. Heckel's input. I mean, you're hearing this. I mean, do you have any, what are your thoughts on the proposal and whether, there are issues that you agree with Anonymous's statement that the mayor's office erred or violated the ordinance?
Are you talking about the same housekeeping?
So I mean, I'm happy to speak with Anonymous, offline over email, on the phone, try and sort of work out a compromise. I mean, I don't really understand the stipulation that's being proposed. I guess I understand Anonymous is trying to carve out the metadata issues. I think we agree those should be kind of dealt with separately along with the other ones and kind of related complaints. I think he was saying that on page 659, his number's 3. Okay, well, let's say like 1 and 3 seem to deal with City of San Jose issues. So those are unique issues. I mean, I'm not really sure what his dispute is at this point. If his position is that we're required to submit affidavits or written declarations, we don't agree with that. We're not going to stipulate to that. It's not required in the law. So that may be a live issue. I'm not sure. I mean, we've represented that we've done the search across personal devices, so I don't know if that satisfies him or not. And then I guess the more sort of housekeeping ones are like number 2. Again, this is sort of one of the misunderstandings about Tyrone Jew. We just didn't understand him to be included among the custodians that Anonymous identified in the first go-round. So I mean, I don't stipulate that was a violation. We just didn't understand what he was asking for. The number 4, the printing versus scanning, I mean, I think the supervisor of records took this up. I mean, it's still not clear to us what information he believes is lacking in those documents other than metadata, which is sort of going to be taken up separately. I think there's a burden issue with printing hundreds of documents to PDFs as opposed to scanning them in. But I mean, we're not really dug in on that, so maybe that's something we could discuss more and work out. Number 5, I didn't really hear him. We did identify a number of redactions. I'm not sure if he's still complaining about that. I mean, we can kind of align specific bases to specific redactions if you'd like us to do that, and provide a key or an index or something like that. And then number 6, again, it seems a little. He says it's not metadata. I mean, there's nothing that's deliberately withheld kind of along these lines that we don't view as metadata. If he's talking about like an image in an email, I mean, I think, again, this is like, he's talking about like the logo that sometimes appears depending on the different ways you view an email. I mean, this is not something we're concerned about. It's just something, we do the work, we try to provide the records. He thinks the image doesn't look the way he wants it to look. I mean, if we want to take up specific issues about that, we can. Number 7, I guess that kind of relates to 6 in terms of, or in terms of how we've maintained the records. I think he said something about WhatsApp. I'm not sure. Just the fact that we use WhatsApp, Jeff Cretin, the communications director, uses WhatsApp for a very limited purpose with DEM, Department of Emergency Management, uses WhatsApp across different city departments just because it's kind of a very like up-to-the-minute thing that they'd want to use in disasters or emergencies. So there's a very limited use of that. We provided records that were on Mr. Cretin's personal device in that format. If there are things that are missing that I think were photos of the mayor, I don't know if we're able to access them on Mr. Cretin's personal device, but I don't view that as a violation. And there may be some technical workaround on that. And then number 8 is, headers, that's the metadata. So that goes to the carved out metadata issues.
Okay, thank you. So Anonymous, I mean, I think
Yes.
you're asking us to make a order of determination at this complaint committee level. Is that what you're proposing?
No.
Okay.
No.
Good.
No. Sorry. No.
Okay, so, I think you heard Mr. Heckle's kind of rundown for those 8 points. Is there anything you want to kind of, take issue with or kind of respond to?
Sure.
To clear things
So,
up? Maybe we're talking past each other.
I think this is what happens when I don't put it in writing. I think he might have understood the opposite. Yeah, I completely understand most of those you don't want to stipulate. I completely understand the city won't stipulate to any of the San Jose issues. They won't stipulate to the header issues. They won't stipulate to the MSG EML issues. I believed, and this is now, I think, a misunderstanding, I thought that the task force's prior ruling was clear, and I also thought from the new productions that Mr. Heckle is doing for other requests, that going straight from Outlook to PDF, as most city agencies do, was appropriate, that printing and scanning is not appropriate, and that both the task force had held that, and I thought Mr. Heckle was now providing records in that way. So that is a misunderstanding between him and me. I thought they would agree to that, but I guess that's not true. 6726, the first supervisor of records response to this, they said the mayor will give you all of those lists. What I'm saying is, if there's a stipulation that the mayor the respondents violated 6726, which requires clear reference to footnote for every single justification, if that's stipulated, I don't need you to go back and do hundreds of pages of footnotes. That's a waste of everyone's time. I just wanted on the record that the Sunshine Ordinance Task Force, whether it's at the full meeting or wherever, is overturning the ruling of the supervisor of records in whatever we agree. Because if we just agree between the mayor's office and me, and they turn something over, and it never goes to the task force, the last ruling on the record is that the supervisor of records denied the petitions. That's why it's important to me, whether it's called a stipulation or whatever, that there's eventually an order.
Okay, so you want something from the task force saying that.
Yeah, and all I'm proposing is if the mayor's office will just agree to the few things that I thought they were accepting, then I don't actually need to argue it, they don't need to argue it, and I will also waive my right to receive production of like 95% of these files once they have to do it in the correct way. Does
Okay,
that make sense?
Yeah, so if and you can correct me if I'm wrong, because I sometimes have to restate these things. You're saying if they acknowledge we made redactions without clear reference, then you're not going to make them go through and explain each redaction. Is that right?
Except for like 10 emails where I do really care. So I'll have
Okay,
like 10
okay.
records, I'll list them out, yeah.
And then the other one was that they acknowledge they should, whatever, how did they produce them? They print them or they just send them to you? What was the other one?
The attachment that there was a supervisor of records response after this presentation was due, so it's not incorporated here. But the supervisor of records, the mayor, in somehow response to that supervisor of records petition, did turn over one additional attachment that was earlier withheld. So I would ask that they stipulate also that was withheld without justification. I don't think there's any argument about it. So.
Okay, but what about the one where you said respondents printed and scanned records instead of providing native? So your understanding was that they were going to start providing them in native?
No.
Okay.
So let me try to state and speak slower because I know I have a problem with that. What I'm saying is I know that the mayor's office will not agree to produce them as MSG or EML files. There's no disagreement. They don't want to do that. I get that. What I thought they had started doing, and I believe everybody had agreed that this was correct, was that they can't physically print them onto a sheet of paper in black and white and then scan them back in and then redact them instead of doing what everybody else does, which is you go from Outlook and you export as PDF. That is what I thought everyone would agree to. So.
Okay, thank you. And Clark, were you going to?
I'm just thinking we're going beyond the function of this committee, which is
Okay.
to just determine if we have enough information and define jurisdiction. I believe that the thought is to divide out allegation number 4 and 8 into a separate file and have that's heard by the Information Technology Committee.
Okay.
If the mayor's office and the complainant wish to communicate with each other to work out if they want to come to any agreements on the other items, they can do that offline. However, this committee cannot take any actions except to find jurisdiction and refer it to the task force.
Right. Anonymous, I think that's where we are. I think I would assume we're going to find jurisdiction here and refer it to the task force. If you communicate, your proposal with the mayor's office and something happens, great. If you put together something in the meantime before the task force comes together, you can of course submit that. And it might make things easier for us down the road. But remember, Kate, do you have anything to add at the moment?
I mean, I guess I'm just trying to see from both sides. I mean, if you all are still talking and it's possible that there may be compromise in further productions, is that, Anonymous, is that something that's possible that that there's future conversations? No.
What I'm saying is, it's not divide 4 and 8, it's divide 8. But what I'm saying is not that they need to produce more information or anything before we go to the full task force. What I'm saying is I would waive my right to receive those things produced in a way that's exactly in accordance with the Sunshine Ordinance if they can agree to stipulate to those violations, because I don't want the contrary decision of the supervisor of records to remain on the record.
Any decision made by the supervisor of record is their decision. It has nothing to do with the task force. Right. We make our own findings independent of any findings made by the supervisors of record.
Yeah, I mean, it's probably a full task force issue, I suppose. I mean, in terms of whether any particular part of because it's one complaint, and there are many different kind of parts to it. And what that complaint ultimately looks like when the task force considers it and votes on it kind of depends on what's presented to the task force at the full task force meeting. So, I mean, I'm not sure what we can do at this stage, other than if we believe that this is ready to move to the full task force, move it to the full task force after carving out. And anonymous, I do think, I'm trying to remember if number 4, in terms of the scanned or non-scanned text searchable PDFs, I mean, I recall that being an issue with some of the prior complaints, and I believe that's something has been sent over to at the committee level. Is that, I mean,
I don't believe it matters if the task force has heard it before and made a decision. I believe that is an issue that the technology committee
Yeah,
can review again.
I thought that was part of the technology committee kind of purview of how to do that, but
yeah, I mean, I thought it was as well, that basically 4 and 8, those components was something that the technology committee would be considering in conjunction with the other related issues. What's the procedure for, I guess, carving those out?
It's administrative. I can just take care of
okay.
it.
Mr. Heckel, I know you were going to say something, but go ahead.
Yeah, if I could just quickly respond to some of those points. I mean, I would hope that we could continue to have a dialogue with Anonymous to maybe work out a compromise on some of these issues. But I think we're a little bit at cross purposes in the sense that he seems to be saying that he wants us to, rather than provide specific things that he wants us to say, okay, we're at fault, we'll take a violation, and then we don't have to give it to you. We're kind of coming at this from the opposite perspective. We believe we should work with him to provide things that he's requested, and if we've missed things that we don't think are exempt, we can work with him, but we're not going to sort of fall on our sword and say, okay, we'll take a violation. Like, he pointed out an attachment issue. These requests have his requests taken together have like hundreds of subsets of documents. An attachment might have gotten inadvertently omitted. There was one that he identified. When it was pointed out to us, we produced it. I mean, I think that's a foot fault. We're not going to say, okay, we violated the Sunshine Ordinance in that instance. But for issues concerning the redactions, if there's other non-exempt information that he's looking for, we can sort of work with him. So we'd prefer to provide the information rather than take the violation if we don't think there was any willful misconduct. And on the contrary, we've made a good faith effort to kind of shoulder the burden and provide the documents.
Okay. I think at this point, you want to make a motion to find jurisdiction and public documents are public and move it to the task force and bifurcate the email header issue along with the metadata issues.
I mean, I think that makes sense. I mean, if there is a way, because I do think, so I'm hearing from the complainant that he believes that the issues are teed up, with the exception of the carve-outs. And from the mayor's office, I'm hearing your point. I mean, I get it that if you can give him documents through, conversation with him and, maybe satisfy him, then before the full task force agree, here's this, then that'd be great. If it can't happen, then it can't happen, and that's something that the task force will then just consider, and I think that could happen in the interim. I know that, I'm sure that there are certain issues that there aren't compromises on, and so, I do think that this is, certainly some aspects of this are ready, and we should carve out the others, and so I would second the motion.
Is there any public comment on the motion?
Just to revise the recap the motion. Motion is to find that the task force has jurisdiction, the records are public, and to refer the matter to the task force, and that allegation number 4 and 8 be divided out of this file into a separate file to be heard by the Information Technology Committee.
Correct.
There being no public comment on that matter, may we adopt that motion without objection?
Yes.
That motion is adopted.
Thank you. Thank you,
Thank you.
Mr. Eckel. Thank you, Anonymous. I know we have another one, so
Thank you.
thanks.
Next on the agenda, file number 19094, complaint filed by Anonymous against Linda Gurul and the Department of Technology for allegedly violating Administrative Code, Section 67.21, 67.25, 67.26, and 67.27 by failing to respond to a public records request in a timely and/or complete manner.
Thank you. Anonymous, you're still here, correct?
Yep.
Okay, into 5 minutes.
All right. So anonymous for case 19094. We're going to begin on page 1023 of the record, which is page 30 of your PDF. On August 28th, I emailed an immediate disclosure request to the Department of Technology for a defined term called the Enterprise Systems Catalog, and a non-immediate disclosure request for their updates to that catalog, which are also required by statute. 2 days later, I had received, no response, so I followed up and filed a complaint. Their first acknowledgement by the Department of Technology was on September 6th. They instructed me to use a web portal called Next Request and said that my email had gone to spam. I used the email that's on their homepage that says how to contact them. They released those records, but using a mechanism that requires you to have a login on Next Request. I asked them to release it without the login requirement, and they gave me what I allege is an incomplete catalog on September 10th. As your DCA says, I don't believe they've ever responded to the non-IDR part of the request. And that was just, it's all one email. This is actually a follow-up to a file called 19095. It's just in a weird order on your docket. Next slide. So I think there's a clear IDR violation here, 6725. 6721B requires that agencies handle requests made via email. They cannot require me to use Next Request, which imposes terms and conditions beyond those of the CPRA. 6721, I don't believe I've ever received a response to the second part of my request. And then there's either a CPRA, Government Code 6270.5, or a 2627 violation because they're excluding certain systems from that catalog, which is on the last slide. So this may be a portion of the CPRA that you're not as familiar with. It is called Government Code 6270.5. It's like Prop G. They are not only required to disclose this list of enterprise systems, they're required to construct it and have certain fields of information in a very specific format, in specific legal requirements. And DT appears to maintain this catalog for everyone. I believe, and it's described very much in the record in a rebuttal to the city attorney, that there are multiple enterprise systems missing from this catalog. They do have a rule that allows them to provide much less information for certain enterprise systems if they don't want to, but they still have to be on there. Enterprise systems is a defined term. I'm not going to explain the whole thing, but you can read Government Code 6270.5 and the full rebuttal letter dated September 11th. I also am happy to do a compromise stipulation, whatever you want to do here as well. Thank you.
Thank you very much. Is there anyone in witness or support of the complainant to speak? Seeing none, is respondent? Please state your name, and you have 5 minutes.
Sure. Good evening, board members. My name is Arlene Ligodini. I am the current custodian of records for Department of Technology. And as suggested by the board, I've submitted on October 7th documents for inclusion into your agenda, packet of supplemental and supporting documents for Department of Technology. It should include a timeline when we receive the request, and then the request detail, that screenshot of the MOCROC that we have it on Next Request, and the inventory, the San Francisco inventory of citywide enterprise of records, which was posted and released to the requester and published publicly for public consumption. I do have my colleague here, Brian Roberts, and I are here to answer any questions you may have regarding the submitted documents that we have.
At all? That's it?
That's it.
Well, thank you very much. Is there anyone, witness thereof, who'd like to speak in support of respondent? Seeing none?
Excuse me.
Okay, so I think there was an early issue of one just not being responded to at all. Anonymous, is that correct?
There was a single email with an immediate disclosure request that they did respond to just late. In the second half, they appear to have never responded. I can't find any response.
Okay. Is there any, sorry, what's your name again?
Arlene.
Hi, Arlene.
Hi.
Is there any response to that?
Okay, so on the timeline that I have, it stated that on Tuesday, September 3rd, that's when Director Gerald actually received an email from the BOS Sunshine Task Force from Cheryl Ledger, naming her as a respondent to a complaint. On 12/17, Director Gerald emailed me, my Arlene, and the DT CFO, Chiama, asking if we receive any public records requests. Both, I have said, I have no outstanding public records requests at that point in time, and that's on September 3rd, 12:17 p.m. And so Director Gerald then at 2:17 p.m., did we receive anything from Mock Rock at all? And I said, nope, we did not receive anything from Mock Rock at all. In fact, on the next request portal, I have researched Mock Rock if there was any, and it came up with 2 instances, and not for Department of Technology at that point in time. So at 2:42 p.m., Director Gerald responded to a complaint, and I said, you know, Cheryl, we have, thank you, Cheryl, for passing along the complaint. Please note that the Department of Technology did not receive any public records requests from Mock Rock, so we will respond accordingly. But then again, on Wednesday, September 4, Director Gerald discovered the request came through a DT service request desk, and the email was struck down, and the department started the investigation as to why the email failed to create a service request. We acknowledge the fact that Department of Technology can receive any wherever public records requests via email or whatnot. But what happened was, the findings are this: emails are not created. Emails that we receive in a service in SNOW, which is service request, it's not being brought to ServiceNow. Are those that have RE reply in a subject line. This is to prevent creation of duplicate tickets. And as explained by Eddie Parsa, our SNOW expert, the email request from Marco was held because of that, because of the RE. But if it had gone through the service request with a regular, subject line that says IDR or immediate disclosure request, we would have received the request and would have created a ticket for it. So that was on September 5 about the findings, and so on September 6, I went ahead and put in the request in our regular portal, which is Next Request. That's what we're currently using right now to track, publish, and communicate any type of public records request. This way, we do have the timeline for everything that we handle for public records request. And if you see the screenshot that I have for the PRR, it tells you on September 6th. It was filed on September 6th, and it was released on the same day. It was released to Anonymous on the email address that he had given us, and I've also published the document for public consumption. Thank you.
Thank you.
And just to confirm with the parties, this issue, are there any, or I guess with Anonymous in particular, is there any aspect of this complaint that needs to be carved out for the Technology Committee? I'm not hearing or seeing that there is a reason to carve anything out, but I just want to confirm that that's your understanding.
Yeah, this is not metadata, this is not formats. I want a file that they're supposed to make in a certain way, and I think they missed some items on there, that's all.
Yep.
So the enterprise system anonymous, is that kind of the heart of what's going on here? The Microsoft Outlook is an enterprise system.
Well, it depends on what you mean by the heart of it. I do believe that the immediate disclosure, if you're ignoring the timeliness and the fact that the second half has never been responded to, and I don't know if the respondent talked about that, because if they haven't, I just haven't found it, I would be happy to. I believe your DCA said the same thing. I don't think there's been a response to the second half of the request.
Okay.
But yeah, in terms of that first half of the request, yes, it is about whether they followed Government Code 6270.5.
Okay, so I mean, I think we have jurisdiction over the issues involved in this complaint. I think the documents are public. So I mean, is there any other
Yeah, I mean,
issues you really want to?
I don't think there's any further kind of factual development as opposed to kind of interpretation that would help the task force beyond what's in the record. Yeah, so I mean, did you already make the motion?
I haven't yet.
Oh,
You can go ahead
well,
and
I'll
make it.
steal it. I'll make the motion that the records at issue are public and that the task force has jurisdiction and that this matter be referred to the full task force for consideration.
I will second that motion. Is there any public comment on the motion? Seeing no public comment? Are you a party? Yes. Then,
He has not made any comment at all during this meeting, so it's at your discretion if you want to.
you can go.
Just had a quick question about what, I'm Brian Roberts with the Department of Technology. So that for the referral to the Sunshine, to the full task force, the issue there is the interpretation of Government Code 6270.5 as to what's what under the California Government Code constitutes an enterprise.
I think that's part of it. I mean, he's alleged a few violations, I think 5. So.
Well, a couple of them are about withholding. For example, 3 and 4. We didn't withhold those records. We provided the entire list of what we considered the inventory. His concern is that, as an example, he's not saying this, Anonymous is not claiming this is exclusive, but as an example, email and calendaring, should be on there. Well, we didn't withhold them, they just weren't on our list, and he's disputing whether or not they should be on that list.
Right.
So it's not a matter of withholding, so I'd argue that 3 and 4 aren't really relevant.
Well, I mean, I think.
Those would be relevant if we were saying, okay, we have this list of 10 enterprise systems, and we're only going to show you 8, and we're not going to tell you why we're omitting those 2. So I think, yeah.
Okay.
Yeah, and I mean, and that kind of gets to, basically the heart of, or the scope of if there was or wasn't a violation. I mean, if there aren't documents that are responsive that are in the department's possession, then there's not a violation, and that would be more for the full task force as opposed to what we're doing here. So there's a kind of an umbrella complaint of the requests, separate requests for documents, and some of them, as you say, they just they don't exist. Others may, or maybe, so it's really at this point, that's more of a kind of, I guess, merits determination as opposed to kind of a general question of whether, the request itself kind of implicates broadly speaking, public records, and whether, so I mean, I think you were here earlier for the issue with the gentleman in the litigation. You may have been here for that, where that's not something that we can really do. The question here would be whether under the CPRA and the Sunshine Ordinance, and then taking in light of the specific request that Anonymous made, and then the efforts that the department made to comply, and then efforts sometimes turn up that there's nothing to give, or that some aspects of the request are asking for documents that aren't in the possession of the department. And that's kind of a full task force consideration.
Okay, so the consideration of whether some of the, a couple of the complaints about withholding, but, so you can't determine, I mean, our list was 100% eventually. There's the one issue about timeliness.
Sure.
Was 100% of that list, so I just don't understand how that could be withholding, but you're saying you just need to forward the entire complaint without comment to the...
Right, because if the complainant believes, for whatever reason, so I mean, I can talk more generally, but in this case, if the complainant believes that there are other documents, and you say, well, there aren't.
Right. This is a single, that's a different question about the, I agree, number 2 wouldn't go away, but 3 and 4, which is a question about the definition of the government code, which again, I guess, and this is just an open-ended question, you would know better than I, is interpretation of the California government code, is that typically in your jurisdiction?
Yes, as difficult as sometimes, an 11-member task force, but yeah, I mean, whether or not the records fall under a certain provision of the CPRA or the Sunshine Ordinance, and then whether, so there's there's kind of the threshold level, right, of how is the law, applied to the situation. And so, but I guess the other point is that if there are aspects of this, so for example, even just the timeliness issue, right?
Mm-hmm.
Were it just left to that, I mean, this one needs to go up just basically, if nothing else, for that purpose. And so there are other aspects of the, if there's several different flavors of alleged violations, it seems apparent, I think, to those of us here on the committee, those sounds like so many more than 2, that it's ready for the task force to look at the record and then have the fuller discussion on kind of the merits of, the applicable code provisions and the act provisions, and whether documents do or don't exist, or should have been withheld or weren't withheld
Right.
because they don't exist.
In this, right, in this case, we didn't withhold anything because we provided what exists that was being requested.
Right.
So it's sort of...
And in that context,
Okay.
sometimes,
Yeah.
I mean, and it's hard to say what happened, if there are other aspects of the complaint, but in the context of where, and it's happened, I've seen it, I've made the motion myself in the task force, where there's not a violation. If there's, for example, one standalone issue, and someone says, I need the documents, and the city agency says that they don't exist, then that's something that at the committee level, we don't really get into whether they do or don't. We send it up to the task force makes a determination, and sometimes says, yeah, we actually agree that the records don't exist, and so there's no violation. And so the task force, what we're doing here is asking the task force to consider, the facts that the complainant has brought forward, and whether there is or is not a violation based on those facts and the task force's interpretation of the relevant provisions.
Okay, thank you.
Yeah, and also nothing prevents you and Anonymous from communicating and narrowing down or clarifying what the issues are in advance of the task force meeting. So if that happens, fine. If not, if it's more muddled by the time we get to a full task force meeting, then that's possible. But, this is really the preliminary low bar. Is the jurisdiction, is the documents public? And we refer it up to the full task force, so. Anyway, any other public comment on the motion? Hear none?
There being no additional public comment, can we take that matter without objection?
Yes.
That matter is approved without objection with Member Wolf being absent. That completes the agenda for today.
All right.
Thank
next.
you.
Make a
Thank you.
motion for adjournment.
Make a motion for adjournment?
Yep.
I'll second it.
The meeting is adjourned.